Hi, in this demo lecture, I want to briefly tell you about how this course will act as a value add when you start working in a law firm. Also, we will deal with some fundamental interesting concepts of corporate law. To understand how this course will act as a value add when you start working in a law firm, it is important to understand the kind of issues students like you face while studying in a law school. Having faced these issues ourselves, we hope that we can help you in this transition in an effective manner. The first issue that we have observed that students face in law school is that there is a general lack of connection between what is taught in law schools and what skills are actually required in a law firm. For example, you may be taught the basic theory in subjects like contracts, corporate law, etc. However, you may lack certain application skills which are required in law firms, which may be required, for example, in drafting of contracts, in legal due diligence, in other transaction-related work. In this course, we will try to help you bridge this gap between the theory you are taught in law schools and the skills which are required to excel in a law firm. The second issue that we will try to deal with is that there are certain subjects that you are not at all taught in a law school. For example, basics of foreign exchange laws, basics of security exchange laws, and other such subjects, which are absolutely fundamental if you are working in a corporate transactional team in a law firm. In this course, we will try to give you a basic idea of these subjects so that you are not caught off guard while you are given any research proposition or any other transaction-related work during your internships or when you start as a fresher in a law firm. The third and the final issue that we will try to deal with is how to maximize your potential during your corporate law internships. We have noticed that while students get the opportunity to work in some of the biggest firms and the best corporate teams, however, they lack the clarity in what skills they need to maximize their potential during their internships so that they can convert these internships into prospective job opportunities. Having interned ourselves in some of the biggest firms and thereafter having guided interns while working as associates in these firms, we will help you focus on the key skills that you require to excel during your internships. Now, having discussed some of the key issues that we will try to address during our course, I will give you a demo lecture on one of the most fundamental concepts that you will encounter while working on transaction documents in a law firm. We will deal with the concept of representations and warranties in a share purchase agreement. Please note that this concept is extremely detailed and nuanced, and a detailed analysis is not possible in a 5 to 10 minute video, and we will cover this concept in significant detail as part of our course. Now, I will give you an example where Mr. X is selling a painting to Mr. Y. In the first case, Mr. X tells Mr. Y that the painting was painted by Leonardo da Vinci. In the second case, Mr. X tells Mr. Y that this painting is the best Renaissance painting ever made. Now, what is the difference you see in these two statements? The first statement is a statement of fact which is verifiable on the date on which it is being made. That is, the painting can either be painted by Leonardo da Vinci or it is not. That is, it can be verifiable against an objective standard. However, the second statement is a mere subjective opinion of Mr. X regarding the painting which he conveys to Mr. Y. That is, Mr. X may consider the painting to be the best Renaissance painting ever made. However, for example, another person, say Mr. A, may not consider that painting to be the best ever Renaissance painting. Now, statement 1 is a perfect case of a representation or a warranty in an agreement, since it fulfills the 3 criteria of what a representation is. That is, first, it is a statement of fact. Second, it is verifiable against an objective standard on the date the statement is being made. And third, the statement is being made to induce the other party to enter into a contract. let's take another example. Let's say you go to buy a second-hand car. Now, as a purchaser, you will definitely ask some basic fundamental questions to the seller. That is, does the seller have valid title over the car he's selling? How old is the car? How many kilometers the car has driven? How old are the tires of the car? Has the car ever met with a serious accident or any major maintenance work been undertaken on the car? Now, the answer to each of these questions that the seller will give to you will be an example of a representation. For example, the seller will give you a registration certificate of the car, which will provide evidence of his title over the car. The seller will tell you, for instance, the car is 10 years old. The tires are, let's say, 5 years old. The seller may even tell you that the car met with a serious accident 2 years ago. However, no major maintenance work was undertaken on the car. Now you see a common pattern among all these statements made by the seller. These statements are statements of facts, which are verifiable against a clear objective standard on the date on which these statements are made. And these statements are being made to induce you to enter into the contract to purchase the second-hand car. Hence, all these examples will be examples of representations and warranties under an agreement. Okay, so now let's come to a share purchase agreement. Now, what is a share purchase agreement? In a share purchase agreement, essentially, a purchaser is buying shares from an existing shareholder of a company. Now, while buying these shares, just like we saw in the example of the second-hand car, the purchaser will want certain basic assurances from the seller of the shares. These assurances are called representations and warranties. These representations and warranties typically form part of a schedule of the share purchase agreement. Let's take two scenarios. In the first case, the purchaser is, let's say, buying 10% stake in a company. And in the second case, the purchaser is buying, let's say, 90% or 100% stake in the company and is becoming the controlling shareholder of the company. In the first case, where the purchaser is buying 10% shareholding in the company, the purchaser will just seek assurances regarding the shares that he is purchasing. Like, for example, whether the seller has valid title over the shares, whether the seller has the requisite capacity or authority to enter into the contract, whether there has been any encumbrance or security created over these shares. Because if there is a security or encumbrance created over these shares, later on the person who is holding the security may come to enforce the security against the purchaser, and the title of the purchaser of over these shares will get affected. And in the second case, where the purchaser is becoming the controlling shareholder of the company, the purchaser will want a lot more assurances from the sellers. For example, the purchaser will want to understand whether there are any significant litigations that are going against the company and what effect these litigations can have against the company. The purchaser will want to understand whether the company has received any significant regulatory notice or action by the regulatory authorities under applicable law, whether the company has been subject to any significant fine or damages by these regulatory authority. So, I hope you understand the difference between the representations and warranties that the purchaser will seek from the seller while buying a smaller stake in the company as compared to while buying a larger stake in the company. So till now, we have understood what are representations and warranties through the example of the second-hand car and how this concept is applicable in a case of a share purchase agreement, a concept which you will very frequently deal with during your stint in law firms. Now, some of you may ask a question that whether all these representations or warranties are common to all SPAs, or in other words, while some representations and warranties are extremely fundamental and may form part of all SPAs. For example, the seller has valid title over the shares. There is no existing encumbrance or security created over the shares while the seller is selling them to the purchaser. However, there are certain representations which are dependent on the legal due diligence exercise which the legal counsel of the purchaser carries on the company. This issue will be dealt in more detail by my colleague Mr. Keshav Parikh in his demo lecture. As an assignment for you guys, please study Section 19 and Section 124 of the Indian Contract Act and analyze how they are related to what we have discussed in this lecture. Thank you.